So hello everyone, welcome back. Wonderful to see so many people and some same faces from yesterday. Before we start our presentations today, Balbir is going to provide a summary of yesterday's proceedings for those who weren't able to be with us. And could I just ask that if you are not actually asking a question or raising or presenting, if you could mute your mics, just so we prevent feedback. Thank you. Balbir. Balbir, unmute yourself.
Oh, usually everybody else does that, and I did that too. Okay, let's start all over again. Good afternoon, everyone. I want to thank you all for being here. We had a really heavy day yesterday. As a reminder and a recap, yesterday we had various professionals from different sectors go over their role in the courts process. And this was important because we have NEVR members from all areas and different knowledge levels. And in order to effectively communicate towards the goal of creating court system recommendations, we kind of all need to be on the same page, right? And so today, we will get insights from NEVR members Rise Women's Legal Center and West Coast Leaf about the challenges that are faced by women or survivors, I should say, and where so their talk and the reports both agencies have written are really important. Some of the things that you're going to hear about, you're going to say, oh, I know this because the clients have told me, right? And so from your experience, you probably will, but having them say it and highlight some of their work that they've done will help us in writing our own report in trying to effectively implement change. And so after the two presentations, you'll be given an opportunity to provide feedback and ask questions based on the information that was presented and your experiences. And then tomorrow, we will be learning about different effective court system options and creating recommendations for what is needed in BC. And this is where we all really need your help, your insight and feedback the most, because we will be learning about the integrated court model and other promising court models. Some of these models have been implemented in other jurisdictions, and the results from these initiatives will be summarized by our speakers tomorrow. We would love feedback from all different members so we can make recommendations that will make a difference to survivors of violence in a way that is achievable and can be implemented successfully. And this means making notes of laws and norms that could get in the way of reform, reasons from our experience regarding why well-intended protocols are not followed in the system, some of the problems that survivors face, methods for increasing accountability within the system, barriers to change, and then potential challenges with proposed systems that could have negative consequences for survivors. So we want to think through that really carefully. We encourage everyone to speak freely when it's time to give feedback and ask questions, but we understand that sometimes it can be difficult to speak up and think of things on the spot. So the recommendation report that we're going to create after the conference will also be sent out for to all our members and all of you for any feedback and edits prior to being shared with different levels of government and other stakeholder groups. So what we want to do is run an effective change campaign to get the change done. We have been talking about this since 2011 when we had our first courts conference. So that's a number of years. And there's been some changes along the way in the court system, which we'll hear about, but not a significant amount where the survivors feel like the justice has been served. So let's continue to learn together with an open mind. And over to you, Jen.
Sorry, I was muted too. This is classic. So thank you, Balbir. It's with great pleasure that I get to introduce Raju Manga, who is the ED of West Coast Leaf. And Raju will be talking to us about issues that arise in family court and in criminal court. And I'm just going to pass it over to Raju right now. Thank you for being here.
Thank you. I have a PowerPoint slide, a pretty lo-fi one, so I'm just going to pull that up and share it with you all. And if someone could just nod and let me know if you see it. It's there? Okay, wonderful.
It's there.
Thank you so much, Jennifer. Thank you for inviting me to speak today. I'm grateful to be here with you all. West Coast Leaf is a member, as Balbir said, of NEVR, though this is my first time coming together with this group. What I'm trying to do with my presentation today is share some of West Coast Leaf's perspectives on the need to apply an access to justice lens when we're thinking about integrated legal responses to family violence. And I'm not an expert in this area at all. And so my aim with this presentation is to really kind of do some context setting that would lead you into Haley's presentation, which is about more recent research that's been done. And then also, hopefully today, the two of us will give you a good foundation for the more detailed and informed discussion that you'll be having tomorrow about the Integrated Domestic Violence Court in Ontario, that Rachel Berenbaum will be speaking to, and then other models for court proceedings, which I know we will have a literature review and then moving into discussion around recommendations. So I'm hoping that I'll be able to give with this presentation some context for those conversations that you'll be engaging in tomorrow. Just before getting started, I just wanted to do a land acknowledgement. West Coast Leaf's office is located, and I live myself on the traditional, ancestral, and unceded homelands of the Musqueam, Squamish, and Tsleil-Waututh nations. We've been trying to think very reflectively and operationalize these commitments to reconciliation. And this week, with the news that we all heard about the unfortunate mass grave of Indigenous children at the residential school in Kamloops, I think it's been particularly on my mind to just be thinking about centering relationships with Indigenous communities as a settler myself. By way of agenda, I plan to give you a brief introduction to West Coast Leaf, where I work, and talk a little bit about the work that we do through the different legal strategies we use. Then I'm going to give a bit of a backgrounder on the context of access to justice as it applies to family law legal aid in BC. And I expect this is a context that many of you will already be familiar with. So I'm not planning to spend a ton of time going over things that may be old news, but I do think it's important as we think about transforming models of legal process to sort of be really mindful of some of that context from where we're coming. And then I'd like to speak very briefly as well about a constitutional challenge that West Coast Leaf has brought to BC's family law legal aid regime. And we hope that with this challenge, we'll be shifting the landscape of access to justice for survivors of family violence in ways that feel meaningful to them and kind of meet the needs that they have. And then finally, towards the end of this presentation, I'm really going to be overviewing challenges that survivors face when they're confronted with multiple legal proceedings relating to family violence, and offer reflections on how we bring that access to justice lens into thinking about addressing those challenges. And I sort of interchange family violence and domestic violence and interpersonal violence. I'm not doing that with any particular intentionality. It's sort of just using those words a little bit interchangeably, though of course they can have very specific and different meanings. So I just wanted to sort of lay that out at the outset. So just a little bit about West Coast LEAF. The LEAF part stands for Legal Education and Action Fund. We were founded in 1985, right around the time when the equality provisions were enshrined in the Canadian Charter of Rights and Freedoms. And the intention or the mandate of our organization is to put that spirit of equality into action using legal strategies. Today, now it's been over 35 years since we've been around, we're still holding to that vision by using strategies of law reform, litigation, and public legal education to challenge gender-based discrimination. Our vision is for an equal and just society for all women and people who experience gender-based discrimination. And we strive very hard to do our work in collaboration with those communities that are most directly impacted by gender discrimination, using an evolving and ever improving, I hope, intersectional and inclusive feminist approach to this work. We're proud of where we've come from and what we've done, but we know that we have a lot of learning to do in making our work better and more responsive to community need. So just on this slide, you'll see we use sort of multiple strategies. Our work has been more recently focused on achieving access to healthcare, access to justice, which is what I'll be speaking to today, economic security, freedom from gender-based violence, justice for people who are criminalized, and the right to parent. And we know that these are not sort of discrete categories. They're also very large categories, and a lot can land within each of them. And they also have a lot of interconnection and relationship to one another. Through law reform, we work to shape law and policy to better align with the needs, circumstances, and desires of equality-seeking communities. At the moment, a big focus of our law reform work is on shifting BC's child protection system from one that's focused on apprehension of children to one where there are supports provided to families so that people can parent. And then in our litigation program, we get involved in cases that will have an impact on how the law is going to develop with respect to gendered implications. We usually intervene in cases that are brought by other parties where we think that a feminist analysis will improve the legal process and the outcome. And there's a case coming out tomorrow, actually, that we were involved in, which is about how courts can exercise their power to allow for canceling child support arrears under the Divorce Act. It's a case called Colucci. So we're waiting eagerly to see what the Supreme Court of Canada says about that. And then finally, we also offer public legal education programming through workshops for both adults and youth about their legal rights and obligations. And we try to do that work through a lens that's critical of the legal system, but also one that, again, responds to what sorts of issues and concerns are front of mind for young adults and youth. So in our access to justice work, we've used all of these tools, and using these tools together, we've really focused on wanting to change the conversation about what access to justice means, to reframe it as an issue with dimensions of gender inequality, and whether, wherever that conversation is happening, whether it's happening in a classroom, in an office, in a legislature, in an online forum like this one, in the courts. That's been one of our aims with our access to justice work. So just moving on now to talk a little bit about that sort of background or context that I said I would offer. It's really trite these days to say that there's an access to justice crisis in BC and across the country. This is very apparent. Access to the courts and to the legal system is out of reach for all but the wealthiest people among us. And there are real limitations on what services are available to anyone who does qualify for legal aid representation services. At my organization, we've been looking at how this crisis, the access to justice crisis, has gendered and discriminatory impacts on women and disproportionately is harmful to women who are looking for protection from family violence. The work that we've done is steeped in research that we've been doing over the past decade or so on the legal needs of women in BC. We published 2 reports earlier, one called Legal Aid Denied and the other called Rights-Based Legal Aid. And those 2 were focused on what were the impacts of the cuts to BC's provincial legal aid system that took place beginning in about 2000 and really kind of started to happen more significantly in about 2002. Those cuts were largely made to family law and poverty law legal aid, and women were disproportionately impacted by those cuts because they were more and still are more likely to be in need of legal aid services for family law and for poverty law issues. And then we had a 3rd report that was a bit later, I think it was around 2014, called Putting Justice Back on the Map. And in that report, in that research, we did extensive consultation with women in 16 communities across BC about how they would like to have their legal needs met in the family law context. And it's through those consultations that West Coast Leaf developed a model for a women's legal center, the Rise Women's Legal Center, which opened its doors in May 2016. And Haley will be speaking with you soon about some of the incredible work that's taking place at Rise. So that was kind of one of the takeaways from this consultation across the province. And in our work on legal aid for women, we highlighted several features of how unequal access to the courts is harmful to women. And back in 2002, Legal Aid BC, it's still also called Legal Services Society, but they did a rebrand and they now call themselves Legal Aid BC. They had their overall budget reduced over a 3-year period. It was cut by 40% overall, and 60% of those cuts were to family law legal aid. Poverty law legal aid services were altogether eliminated, and the availability of family law legal aid became quite limited in terms of what was covered and how much time you could have with a lawyer. And those consequences are still very much being felt today. And so it's also important, I think, to note that the cuts to legal aid arose in a broader context of overarching cuts to social services, which disproportionately impacted lower and middle income earners, and particularly people with primary childcare responsibilities, folks who were already in lower waged and more precarious employment, or people who were relying on income supports. And so, oh no, my cat is maybe going to come into the frame. Apologies if you see a cat walk by. At that time, there were also amendments to the Legal Services Society Act, which is the law that sets out the mandate for legal aid in BC. These changes were also made in that early 2000 timeframe. And what the amendments were doing is moving entitlements to an effective legal aid program out of the legislation and into a mandatory memorandum of understanding and budgeting process that happens between Legal Aid BC and the province. And so in our work, we've highlighted kind of these 3 primary limitations to women's access to justice via legal aid in the family law context. And those are financial eligibility cutoffs. That cuts off access at the front end. So it's a barrier to even getting in through the door. And to be financially eligible for legal aid, you basically have to be poorer than a single woman working a minimum wage full-time job. And you need to have very few assets, and you might actually need to liquidate even the modest assets you have before you can be found eligible. So that's kind of one area that we've identified. Another is that there are limitations on the amount of service that is provided to you, even if you do get through the financial eligibility door. Once you've exhausted the hours allotted to your family legal aid file, which has been kind of hovering in the neighborhood of 35 general prep hours. And there are opportunities for discretionary, modest top-ups to that. Your legal aid lawyer is no longer going to get paid, and they'll typically withdraw from the case. And Legal Aid BC themselves acknowledge that the service they offer wouldn't be able to stabilize, let alone resolve many family law matters. And then a third kind of area that we've been looking at is situational coverage. That's also another way in which family law legal aid is limited. It's not intended to provide you with legal aid services for the full spectrum of issues that could come up in a family law proceeding. They're limiting to situations where an immediate court order would be necessary to ensure the survivor's safety or their children's safety. And typically, despite the breadth in the language around family violence in the law, still very much looking at physical safety as kind of more where the idea of violence and safety is still centered. There can also be legal aid coverage if there's a serious denial of parenting time or contact or access with your children, or if there's a threat of the child being removed from BC or otherwise being withheld. And of course, there is some discretion built into the system so that the person at Legal Aid BC who's reviewing your application may be able to give you some additional time, may be able to decide whether that they'll make an exception, but it's challenging to figure out what factors are going to go into the exercise of that discretion. And it also depends, because everything is tied to a budget that has to be approved, where in the life cycle of the budget your call happens to take place. Is your application made early in the year or late in the year? These kinds of things can impact what service you'll get. So the upshot of all of this is that the types of issues that Legal Aid BC will cover have become limited in scope. There's also a very low financial eligibility criteria that leaves many people who could hardly be seen to be able to afford counsel deemed to be able to do so because they're not poor enough. And then a one-size-fits-all sort of cap on lawyer hours for general preparation, which again doesn't speak to kind of any of the complexity of a particular file, any of the unique needs that particular client may have. It's pretty much kind of a one-size-fits-all approach. And then because BC's legal aid system is not able to exceed its budget and can't predict need, decisions about extending hours, as I said, are often done in a really arbitrary basis and can be very time dependent. So that's just a little bit of context there. The disproportionate harms to women of BC's legal aid regime are, we think, plainly obvious. As we know, and none of this will come as a surprise to this audience, women on average earn less than men and are left poorer after a relationship breakdown. As a consequence, it means they're less able to afford lawyers, where they have to use the courts to seek vindication of their rights or to secure safety and security. They're left even further behind. Often they might have to borrow or use up modest savings to be able to access courts which may then leave them more economically insecure in the future. And it sort of perpetuates a vicious cycle where in order to potentially seek some physical safety, you may be foregoing any potential economic safety and security you might have been able to secure. And of course, women are still disproportionately primary caregivers for children, which means that they, of course, have costs associated with those responsibilities, less opportunity to earn, lower earning potential on average in our society, and more at stake often in court. And the gender disparities that we see in our society are only kind of magnified in the context of access to justice. And of course, again, this is not going to be news to this group. Women are also far more likely to experience family violence, particularly interpersonal violence or domestic violence. And so their safety, the safety of their children, is often at stake in these proceedings. And then where they're not eligible for legal aid, or they run out of legal aid hours before significant issues are addressed, many times women are left to represent themselves, to seek protection where violence is present, and sometimes compelled to participate in those proceedings with an abusive ex-partner on the other side, who may himself be using the legal system and legal tools as sort of continuing tactics of control and coercion. And it's been shown in research that without access to legal advice and representation services, family law proceedings can become more protracted and more complex, increasing a risk of family violence with each point of renewed contact and stress during the process. And children suffer as well from this, apart from family violence to which they may be subjected themselves or that they may be witnessing. If the court does not have all the necessary information before it, judges will not be able to determine truly what's in a child's best interest, which is kind of the penultimate standard against which decisions should be made or are intended to be made in our system. And while we do have progressive family law legislation on the books here, which includes, as I said a little bit earlier, a more expansive view of what is family violence, those laws become largely irrelevant if women cannot access remedies under them. And I think it's maybe the slide that I just went over, but that where access to the courts is inequitable, the outcomes can also be inequitable. And this is shown in our experience in seeing the concessions that many women will make in an effort to sort of cut the litigation off, because it's perpetuating harm in their lives. And so they try to just kind of walk away from what they're entitled to if that may be more a safer or a more reasonable thing for them to do. And then of course there's the use of tools like psychological assessments that are, intended or purporting to be neutral aspects of the legal process, but often become tools of disenfranchisement for women, or are used against them in ways that were probably not originally intended. And psychological reports in particular can be very damning, where you're unable to, you can't afford to challenge the findings, and those findings are then kind of used against you again and again in the court process. And of course, I alluded to this too, where their ex-partner may be represented by a lawyer, or even if they're not represented by a lawyer, women are more likely to be targeted by litigation abuse and harassment. And that includes things like bringing many court motions as possible early in a proceeding to try to exhaust her resources, including legal aid hours, knowing that those are limited. So that's sort of some of the picture that we've seen in in our work on legal aid and access to justice in the family law context. So through the years, we've been advocating for increased funding along with many, many other organizations and individuals. We've asked the government to increase the funding that they give to family law legal aid in recognition that this current regime that we have isn't serving the needs of the people that it says it's helping, and in some cases actually causes harm to women who are fleeing violence in their relationships and looking for protection. So in 2017, we launched a constitutional challenge to BC's legal aid regime, the family law legal aid regime, in a case called the Single Mothers Alliance and Nicole Bell v. British Columbia. The challenge is both modest and ambitious, if I can put it that way. If we're successful, we will have established a constitutional right to state-funded legal aid services in circumstances where women of low and moderate means are seeking access to court remedies to protect themselves or to protect their children from violence. The underlying rationale that we have for this challenge is what we've been hearing again and again from many women who'd reached out to West Coast Leaf, that the regime as it's designed and currently being implemented is causing harm to them by forcing lengthy periods of self-representation, and often in the context of complex and sometimes multiple proceedings that involve family violence, or they're given just enough service where they have an interim order that has terms that they're stuck with because they're not able to kind of go back into court and have those changed, or there isn't a real resolution of the issues, and kind of every point of contact with the criminal or with the legal system rather is kind of another flashpoint for violence and harassment. And at the end of the day, there aren't meaningful remedies being provided for protection for themselves or for their children. And so the challenge is framed around women's equality rights and rights to safety and security, both from a physical and psychological sense of safety and security, as well as around access to justice as a kind of a constitutional principle. And while it's narrowly focused on access to state-funded legal aid for the subset of litigants who are experiencing family violence and have kind of a lower modest income, the way we think about and the way we understand access to justice is it goes well beyond just getting somebody into the courtroom. Access to justice has to be meaningful for it to matter. And we can't just kind of stop at the access part and overlook what the justice part of that means. And in our view, in the work that we've been doing and what we've been hearing, meaningful access to justice is not going to be possible until actors in the legal system have more nuanced and complex understandings of interpersonal or domestic violence and the impact that it has on individuals and families and communities. Janet Mosher, who is an academic in Canada, has done a ton of work in this area around thinking about the connection between access to justice and violence, and domestic violence in particular. And she has a way of putting it that we need to sort of move beyond a reductive and incident-based understanding of domestic violence that totally continues to dominate in the legal realm. And by kind of shorthanding to this idea of domestic violence as this sort of incident, these kind of flashpoints, and having that sort of situational kind of understanding of domestic violence in the courts, we kind of end up as a legal system silencing women's narratives of abuse and minimizing the harms that they experience. And we sort of have this idea, especially in the legal community, that, you know, engaging with the legal system is going to be a positive, justice enhancing type of experience, and that's not what we're hearing from people that are actually engaging in these processes. Legal actors need to have a far deeper appreciation of domestic violence and how it's being deployed and enabled by the legal system in many cases, and other social structures and institutions that we have. You know, that we end up in a scenario where some women are more vulnerable to violence, have fewer resources to exit, but are still not constructed as kind of deserving of having a proper kind of adequate and sustainable legal remedy. And so our kind of approach to thinking about access to justice has been that it's not really access to justice if we don't have system actors who are competent to understand and deal with the complexities and dynamics of domestic violence. And that if we're going to think about alternatives to the status quo system, that will, without kind of really deeply rooting those systems in this like thicker conception of access to justice, we might risk replicating some of the experiences that women are having with our current framework for legal responses that, you know, I think many of us recognize are just not working. And, you know, at best, maybe what we create will be indifferent to those lived experiences, and at worst, they may actively be harming though particular and lived experiences of women who are experiencing violence. So now getting us to where we are looking at for this conference, like the sort of idea of what options are available, what else can be done in BC. I'm going to turn now to looking at the impacts of our court system's fragmentation in the context of family violence. And research has been done in this area by people a lot smarter than me. Donna Martinson, Linda Nielsen, Janet Mosher, Rachel Birnbaum, who we'll be hearing from tomorrow. There are lots of others who've been really kind of digging deep into court system fragmentation and what it means from the perspective of the end user. And many of these researchers and lots of studies from within Canada and outside of Canada have kind of identified court system fragmentation as one of the leading causes of a failure to protect women and children. And it's not unusual, as we know, for a particular family to be involved either in sequentially or even simultaneously in, you know, 2 or more court processes. And, you know, typically these may be bundled like a family law case, a criminal case, and a child protection case, or there could also be an immigration proceeding as well. And there's sort of areas in which these multiple types of proceedings kind of coalesce. But the legal system we have is not designed with a seamless or collaborative response. It has very rigid structural divisions that separate you know, a criminal matter from a family matter, from a child protection matter to an immigration matter. And sometimes as a result of that fragmentation, we have systems that are working at cross purposes. And when they work at cross purposes, that can really undermine public confidence in the administration of justice, as well as just, you know, really putting people through the ringer and wasting a lot of resources, not to mention financial resources, but like even community resources, therapeutic resources. There's a lot of sort of wastage that can happen when we have systems that don't speak to each other and that are kind of working to shape people's experience in contradictory ways. And in cases involving, I mean, that's kind of maybe true across the board, but in cases involving family violence, this is particularly challenging and particularly acute to have a fragmented legal system, because they may be these different processes, whether it's a criminal, family, child protection, immigration, they're operating separately in pursuit of different types of goals and objectives, and they're using different methods to get there. And, you know, just looking at the criminal justice and family law systems together to take two, the impacts of fragmentation are seen through the different purposes that those two systems have. A criminal justice system will be prioritizing like a fair process for the accused person, a preservation of evidence, with kind of this idea that the state is there and there's a public interest and a public safety dimension. And that doesn't always line up with how judges approach family law proceedings, for better or for worse, where judges are focused often on, you know, maximizing contact for the child between their parents, or sorry, among their parents, with their parents, and what would then be in the best interest of the child. And of course, there are different interests at play, still public interest, I think, because we as a society have an interest in stopping violence, particularly gender-based violence, but there are some sort of on some gut level, like different things that are being attended to. And of course, like as the folks that are sort of navigating these processes, there's not only the inconsistencies across the system in terms of what the system is aimed at doing, but there's also grappling with these sort of different kinds of processes, different sets of experts, different judges, different sets of lawyers that are attached to these different legal systems, different timelines. And of course, many of the people within the system, you know, don't necessarily understand how various parts will impact themselves. And I think, like on the slide, I've got the consequences of different proceedings are not well understood. And I think that's mostly, especially true in immigration, which is, you know, a very different kind of legal realm from the courts in which family law and criminal matters are heard in BC. It's within federal jurisdiction for one thing, but then also there's a number of different processes and it can be highly technical and complex. And I think often even judges will not necessarily know what immigration consequences are going to flow from particular findings or decisions, or how information may be used in other kinds of proceedings. And then the safety nets also fail when these systems and the services associated with them, like any kind of court-ordered counseling or interventions for substance use, for instance, any kind of parenting counseling type programs, when those also are not operating with coordination, that can also be very harmful. And survivors are often compelled to jump through lots of hoops to meet these expectations that are coming at them from different elements of the legal system, but their own safety needs are maybe not kind of addressed in that. They may have to compromise their own safety needs, or just be okay to kind of put those at the end of the line while they try to navigate these different expectations. So just in terms of moving along, just being mindful of the time, there's also system-wide challenges that are going to be experienced kind of across the board. These are also well documented in the socio-legal research that's been done here in Canada and in other places. And some of these are indicated here on this slide. Non-disclosure of violence often for very good reasons. Inconsistent understandings of the nature and dynamics of domestic violence, both across different legal systems and among different system actors. before with the Family Law Act, we had a different kind of definition of violence that was operating under BC's Family Law Act as under the Divorce Act, which is changing, but there certainly is inconsistency across the board. Litigation tactics can be used by accused people or the perpetrators of violence to kind of continue to harass or intimidate survivors. And that can be, excessive use of different motions brought before courts, coming towards before different judges in different registries, filing multiple claims, different places, and we've even seen, situations where claims are filed in like different countries, all kind of intended to overwhelm and intimidate. Differences, of course, in like the sort of timelines, standards of proof, rules of evidence. I spoke already about the limited knowledge of the impact of decisions. Duplication of effort often, and orders and agreements that are not serving any kind of common purpose. They're not complementary. And so an example of this, or an example where sometimes people fall between the systems, is in the criminal process. Like if the Crown ends up dropping criminal charges, the accused person may seek disclosure of information from the police about the domestic violence investigation that had been brought against them. They could potentially access Freedom of Information Act type processes to get that information. And so if you're a lawyer who's supporting a client who's experienced family violence, domestic violence, you will want to know if those kinds of applications are being made. You'll want to consider whether that information that being disclosed to the accused person, which they have a right to access under Freedom of Information, could that negatively impact your client, her safety, or the safety of anybody who was a witness? And you have to think about sort of client safety planning and things like that. And that's just kind of one off the top kind of example of where these systems can maybe don't speak to one another, and you really have to be on it and maintain really good solid working relationships with police to know that these kinds of applications could come, or just even be aware that that's a possibility. And often there's a really heavy reliance placed on the outcome in the criminal justice system. And that's sort of a verification of real domestic violence happening. And that's problematic for lots of reasons, but also there are many survivors, as we know, who for very good reasons, like will not report to the police. And that can be that they, are afraid of losing their children through child protection. They, may be experiencing shame. They're afraid that they will lose their housing. They distrust law enforcement for whatever reason. There may be immigration consequences. There's all sorts of reasons that people may not kind of go the criminal route, but often the criminal process is kind of seen as the real kind of verification that something, that real violence took place, it really happened. And if family lawyers in courts kind of discount patterns of domestic violence that don't result in a criminal charge, then the vast majority of these violent experiences are not going to actually be considered by the court at all. And that, I think, can result in decisions that are very challenging and very difficult. And I think sometimes it's kind of helpful to think about, if we contrast the legal system we currently have with our healthcare system, it doesn't really make a lot of sense. Like, we wouldn't think that it would be reasonable or effective for people to sort of like fix their own broken arms or make their own medication or give themselves heart transplants. And we wouldn't really have confidence in a system that took a fragmented approach to health, where each health care provider was operating separately. They didn't have any information that others even existed, and no information about what treatment a different healthcare provider had suggested, or that you'd been encouraged to take a particular medication and for what reason. we would think that's like very bizarre to have a system like that, but we have a system, the legal system, that really does operate with many, many silos, and we sort of expecting the public, and especially people who are facing like increased burdens as a result of marginalization, to navigate their legal care largely on their own without kind of structures or supports. And so I've talked about the challenges that sort of exist already. And then I've got a slide here where there are commonalities. It's not like everything that's happening is so sort of disparate and disconnected. Often we have the same people involved and impacted. Often there are common facts. There will need to be supports and services to address those common experiences. Proof and impact of violence will be necessary. We need well-trained system actors. And at the end of the day, I think we're all looking for just equity-based resolutions to these problems, to the experiences. And so really, it kind of, I think one of the things that comes across to me in this is that that our kind of appreciation of this is that context really matters. Judges are going to need to appreciate the lived reality of the people who are affected by their decisions. That's what's going to ground a notion of access to justice that just goes beyond kind of getting somebody to the courtroom door and then kind of leaving them there to fend for themselves. And so when we're talking about access, we also need to be talking about justice, and how do we ensure that judges will appreciate that lived reality of the people that are affected by their decisions, especially where we're talking about domestic violence. And so some of the things that I expect we'll be hearing about later today and tomorrow, I think are around this idea of approaching safety in a really holistic way, so that it's something beyond freedom from violence, which is often how it's framed within the legal system. And we often talk about greater system coordination and information sharing as very important and necessary to improve decisions and coordinate our services better and enhance safety. And I think those are all really important considerations, and I think there can be a lot gained by coordinating and information sharing. But I think there are some cautions to kind of think about also in designing something that is really going to do what we want it to do. And I think that kind of at the center of that, I put thinking about safety as an integral component of this thicker conception of what access to justice should be. We might want to think about, like, for instance, around information sharing. There's lots of questions in my mind about, how does it work if counseling records are disclosed in one kind of proceeding? How does that affect participation in counseling connected with other kinds of cases? What if you have to produce child protection records to an accused person who's a perpetrator of violence? How does that impact children that may be in need of protection? How would we ensure confidentiality? How do we kind of think about the system itself as a site of often racialized gender discrimination and violence? And can we design the system so that it's not just kind of putting different pieces together and making that be the new model, but really kind of developing something that's quite transformational and quite transformed in how it works. And these principles that are here, these 7 principles, come out of some really interesting work that was done by the Australian Law Reform Commission. They sort of looked at the treatment of family violence across a range of different areas of law. They looked at child support, family assistance, immigration, employment, privacy, pensions, all sorts of things. And they kind of looked at safety as the touchstone. And again, they defined safety as more than freedom from harm, but like access to financial security and independence. And so then what they said was that they kind of did this work, and they identified these 7 principles that they think are really important in grounding an integrated approach to addressing family violence or domestic violence in the law. And so these are, I think, fairly self-explanatory. Seamlessness is, like taking the perspective of the user. Like, let's look at the system from the point of view of the people who are engaging with it, whether by choice or by compulsion. And how do we think about training and awareness and service delivery from that perspective? How do we ensure that people's safety concerns are fairly heard, properly heard, responded to, that the safety concerns are not exacerbated by the system itself? How do we avoid systems that are overly complicated, in which definitions are inconsistent? Where there's complex pathways to get an answer, and how do we avoid having survivors kind of re-traumatized by having to talk about their experience kind of over and over again? Are there ways in which we can do that? And also, like, how do we protect self-agency and autonomy in these systems so that the folks that are experienced the violence that are navigating the systems are making the decisions about the things that impact them? Again, privacy, I use some of those examples, I sort of pose those rhetorical questions, but I think they're real about use of different kinds of records in multiple proceedings. How do we navigate and manage that? And then system integrity, which is intended to be a requirement that anything where a benefit or a beneficial outcome is possible, that requirements to verify family violence are appropriately scoped to that benefit, so that we're not kind of, again, forcing people to kind of go through these hoops all the time. And so just in closing, I'm offering these kind of 7 pathways, or 7 principles rather, as a pathway towards thinking how we might be able to search out new approaches to addressing family violence through the legal process. And I think that, again, kind of being a bit of a broken record, but that thicker idea of access to justice is going beyond merely kind of clearing a path to the courthouse door is really important for understanding what these more effective and impactful options might be, and how they might support women fleeing violence. And so I will leave it there. I think I made it in just under the mark, which is a proud accomplishment for me, because I'm a very talky person.
Thank you, Raji. That was very informative. Some of you may have noticed that there's a hiccup in our timeline. So it says that Haley would be starting in just after 2 o'clock, but we're going to take a 5-minute break, and Haley will add the time on at the end. We just had a bit of a problem. So everybody, it is, if we can now come back at 2:05. And there will be, of course, a Q&A later where you can ask all those questions that are in your mind for Raji and Haley at the same time. So we will return at 2:05. And thanks again, Raji. Hello, everyone, and welcome back from your very quick break. We're now going to move ahead for the next hour with Hayley Rymack from Rise Women's Legal Centre. And Hayley's talk is entitled, "Why Can't Everyone Just Get Along? How BC's family law system puts survivors in danger." Hayley, over to you.
Hey, thank you, everyone. I'm wanting to make sure. Okay. Is anyone on screen to give me a thumbs up that they can see it? Everyone's video's off, which is no problem. Okay, thanks, Raji. Okay, so yeah, thank you all so much for being here and having me. It's great. Such a great honor to follow Raji too. That's very exciting for me. I am a lawyer with Rise Women's Legal Centre. And today I'm going to be talking primarily about our research that this is the title of our report, Why Can't Everyone Just Get Along? And I'm not giving legal advice. And I always just want to mention that I'm going to be discussing family violence, and some of the content includes direct quotes from survivors of violence. So everyone has their video off right now, which is great. I always say that that's one way that people say they don't get so much Zoom fatigue, is feeling like they don't have to be on camera the whole time. But yeah, and another piece is if you find that it's a lot right now, it is going to be recorded and available later if you find you want to step out. And I also just take this time to mention that our research was on experiences of women and their experiences of family violence, but recognizing that violence happens to all people of all genders and all types of relationships. But all of the women we spoke to were in heterosexual relationships, and the violence they experienced was by men. So here's the cover of the report, and it came out in January. And just a bit of background before I talk about our findings. It was over the course of 3 years that we did the research, and from 2017 to 2020. And we mainly wanted to ask, since the Family Law Act came into effect in 2013, what ways does the legal system respond to violence? Because as many of you will know, in 2013, the Family Law Act incorporated this very expansive definition of family violence based on lots of consultation and lots of evidence about the fact that family violence needs to have all these other elements within it to fully capture it within the definition. And there were other positive pieces as well. For example, lawyers and dispute resolution professionals have to screen for family violence when they're meeting with clients and tell them about options available for them if violence comes up, and those types of things. And just to briefly say that we tried to be quite comprehensive when we were looking at this research question. So we did a variety of things and tried to reach out to people who weren't just lawyers and hear about their perspectives of how the legal system was doing as well. Primarily what we did was talk to survivors of violence in focus group discussions. So we went around BC to 27 different places and met with survivors that way, and were able to overall in the project speak with over 160 survivors approximately. And I know everyone here comes to this conversation knowing so much about violence already, and you're all well versed in these issues. I just want to kind of situate us in this again, that we know that with COVID, the incidence of violence as well as the severity of intimate partner violence has increased dramatically. So these are the numbers before COVID, that about 1 in 3 women experience intimate partner violence, and about 48% of marriages end in divorce. So this really means that there's like family law, family violence should really just be seen as one sort of thing to account for. You can't separate it, as Raji was saying. There's this systemic problem with trying to put family violence separate and see it as rare and see it as something that comes up in these really extreme cases that aren't that common, but it's just so much a part of family law that it needs, but it's not viewed that way, and it's definitely not designed that way within the current model. And we also know that people are at such a high risk upon separation. So women are up to 6 times more likely to be killed by an ex-partner than a current partner, and over half of all intimate partner violence occurs at the end of the relationship. So this really means that people working in family law and everyone encountering someone going through a family court proceeding are potentially working with someone who's not only at risk, but at the most risk they've been at in their relationship and potentially will ever be at. And yet our research shows that they're really not equipped with the knowledge to understand their safety risks or to truly assist them. Overall, what we found was that there's current myths and stereotypes and sort of this patriarchal system that really puts women and children in danger. And there's overall, bottom line, such a lack of understanding of family violence and violence. And the system itself is inaccessible. Raji talked and helped to provide a lot of information about what people going through the court are facing, particularly without a lawyer, and the costs, and then going through the system itself often being used to further the abuse. So overall, what our recommendation was within the current model, we do also recommend a different model, but with what we got, people need to have education on family violence, and there's the lack of understanding that exists puts women in a more dangerous position. So the system that is currently operating is not neutral. People aren't going through it and maybe it works, maybe it doesn't. It is actually truly putting people in a more dangerous position often. It's often itself extremely traumatizing, and it often itself, through its processes and procedures, actually exposing people to further risk. And a lot of that is centered on this idea that family law and family violence aren't always potentially working together, and it's not built with that in mind. So just to kind of briefly go through this, what women talked to us a lot about was just not being believed, not ever really getting the opportunity to have that access to justice or have that access to safety because their experiences weren't believed. So Dr. Peter Jaffe kind of described this 4 stages of women who come forward to try and describe what's going on when they're going through family court. And I really like the way that this is broken down, because this is also what women described over and over. So first, there's this stage of really not being believed. And then maybe you get past that and you're told, well, it's not really that serious. That happened a while ago. Well, it doesn't sound like there was anything physical. So surely there's nothing really going on. And it's just minimized. There's no real recognition. And then there's potentially, you're told, okay, well, that's what's happened to you. Maybe it is recognized, but there's no real connection between how that impacts the children. And the best interest of the child. And then finally, sort of basically get over it and put the past behind you. Family law is very forward looking. Let's come together. Let's settle this. Let's resolve this at any chance possible. Let's get out of court and let's just make something quick and look forward. And that's what women are being told all the time, without real recognition by people who truly understand their actual safety risks and the safety risks of their children. So the current knowledge gap that we heard about over and over is really that non-physical violence is not being seen as violence, and it's being completely ignored overall. And so sort of as a society, I think when we think of violence, or when we're learning that word and sort of beginning to understand it, we think potentially of fists or of this physical encounter. But as we know, and as very smart people wrote in the definition of the Family Law Act, the family violence actually has 6 parts, and it includes psychological and all of these non-physical types of violence, because they're so essential to understanding family violence, and they are family violence. But lawyers not recognizing it, judges, and not giving it any weight, not understanding the connections between, for example, stalking and the increased risk factor for domestic homicide, people being told that's not going to be taken seriously, or just in general, having conversations with their lawyer and describing their experience, including the threats and the financial abuse and the litigation abuse, and it just never really cueing in that that lawyer's dealing with someone who's experiencing violence and at risk. So that was a big finding. And I'll put in a positive note before I say something else negative, but and just a positive note, overall, our findings are really about the system failing, but there was, of course, so many experiences of women who were working with people who were well-versed in violence and who understood, and who really did assist them, from police to lawyers to judges to sheriffs to advocates. But we found that non-physical violence is often ignored, and that's not to say that when people had experienced physical violence that they then were being treated, that there was necessarily safety concerns that were taken seriously. It's just to say that at least people who relate those experiences, it was seen as violence. So litigation abuse, this was a big finding for the people that we spoke to, because they're often going through the family court process and they're not represented, and they're with their abusive ex-spouse who has this avenue to continue the abuse. So for example, a spouse, or there's this quote here, people often do not understand that for some dads, custody is about control. So we spoke to women who the father had potentially really had no parenting time up before the actual separation, and then asked for sole custody of the children. So of course that requires responding in this ongoing litigation process. And then if that person is self-represented and they're both self-represented, you're always going to be sort of in contact. You can't get away. You can't get away from allegations brought up against you. You're always having to respond. It's very, very difficult and very common. And this one woman explained, he lies and harasses me through court orders. The court ordered me to give my address. I'm not going to give my address for my own protection. And then she was threatened to be fined. And just aside, there's this negative view towards litigants in family law. A lot of the times they're seen as sort of these high conflict people who just can't work it out, and why are they even in court, wasting all this time and resources, and why don't they resolve outside of court? And I think that we all recognize that's not an option for everybody. It's not an option to opt out of court when you are being brought to court by an abusive ex-spouse, or when you know that there is no other alternative that's going to work for you, and some people just have to go through it. And it's those cases that are being often heard in front of people that don't necessarily have that understanding that this is a violent situation before them. So women talked a lot about really to get help and it putting them in a more dangerous position or just making things worse. So not being believed. And one woman said, my lawyer told me I presented horribly in court and to let it go because no one's going to believe you. It sounds like you're exaggerating. And then one woman said, once you've been victimized or been the victim, it falls on you to prove it, but you don't just prove it once. It's like continuing over and over and over again. It's never just a one-time deal, say your story and walk away. So as a result of not being believed and having their experiences minimized or ignored, women are often not asking for what they need, but what they think they may get. So just about like the not being believed, we aren't necessarily at this point talking about, you know, going through a criminal trial and testifying and being found that, you know, the proof beyond a reasonable doubt isn't there. We're just talking about going to your lawyer or going to the police and not being able to even get your foot in the door. And women described having, or one woman's story sticks out to me. She had this, these experiences of physical violence. And she just said, you know, if these happened on the street, if I was assaulted by a stranger, and she was a white woman, she's like, I feel like the people would be outraged. I would get, police would come right away. But because these are happening in my home, no one believes me. And that's sort of just this piece about not being believed. The barrier is so high once you bring up that it's your intimate partner versus if it was a stranger. And that's the part that stops people. So we did a survey with family law lawyers, and one lawyer said, you know, there's such a disconnect between family violence and parenting rights. My experience has been that one parent can harass, intimidate, and scare the other parent and even breach protection and conduct orders and still have full rights and responsibilities to a child of the relationship. And that's what women described over and over, is that, you know, I had this protection order, he breached it, nothing happened. There's sort of this piece of no accountability for when violence and breaches and flagrant disregard for court orders is happening that should cue in that there's been some potential safety concerns. And at the end of the day, the impact that this has when we're talking about family proceedings, most of the people I spoke to and who go through court are often going through it for parenting time. And so Susan Boyd and Reuben Lindy, when the Family Law Act first came out, they analyzed, okay, what's happening now that we have this great definition of family violence? And they found that it's a positive step. Judges are identifying family violence more, but then the assumption still tends to be towards shared parental responsibility and even shared parenting time as appropriate goals, even where abuse was present. So there's sort of this this piece that, yes, okay, there's violence, but then actually making safe parenting plans or a true analysis of what that looks like and what impact that's going to have on the children is still what's missing. And the problem with that is that we heard over and over again is that children are being put in really unsafe parenting arrangements because they're being ordered to spend time with their abusive parent. So what the first quote says, my daughter, every time she was forced to have a supervised visit, would come home and pee the bed and throw up and scream and have temper tantrums, and the court didn't care every time I recorded. And then she goes on. And just to say that what Raji said of people who maybe yourself or you're represented and you get some kind of interim court order and it's not good. And now you're self-represented and you have ordered visits, and it's just so many barriers to sort of going back and having that order changed or having any so people are really stuck with these orders. So people talked about how difficult it was and how re-traumatizing it was for their children to go on these visits, but they're court ordered. They also talked a lot about being scared of the very real sort of threat of looking like you're alienating your child if you don't send them to their father, and the threat of, if I don't follow the court order, if I don't give them parenting time, that's actually going to decrease my potential for parenting time and put us even in a more unsafe situation. Because right now I know that she goes there every however often. But if I start trying to change that, I don't know what's going to happen, because he's going to say that I'm lying and making it up. So when we talk about the fact that this system doesn't work, and that people over and over said that no one believed them and that they couldn't get safety, we just sort of recognizing the severity of what that really means, and what we know about domestic homicide rates, and that they're going, not down, that's for sure. So when we did the focus groups, I didn't actually ask anybody any questions about what their experiences of violence were, because for the people who attended, they'd already said, sort of met our 2 criteria, that they'd experienced family violence under the definition in some way, and that they had a family legal matter since 2013. So then they're there discussing their experiences with the court or the police or their lawyers, primarily sort of the legal system. And over again, I noticed while there, but also in reviewing the transcripts, that so many people described that they had experienced death threats, particularly if you ever leave, I will kill you or I'll kill the children. And so we went back and did a survey, and our survey responses were only 27 people, so not a huge amount, but of those, 70% said that they had experienced some of this kind of threat. So we also asked people what it was like talking to their lawyer about family violence, and almost 50% of women, so 44% of that survey, were told by their lawyer to not bring up family violence. And that's, again, a really, complicated piece that could be its own presentation, because often that could be a lawyer who's actually very informed about family violence, understands it, has taken, every course there is on it, and is potentially in a community where they know their judges, they know how this is going to look, they know the myths and perceptions that are going to come up, and they think that maybe it's not in their client's best interest. But this number also includes people who, as I mentioned before, when you talk about psychological violence, or you mentioned stalking, the violence cue and red flag is not necessarily going off because they've never been required to take any education on family violence. Lawyers are required to screen for family violence, but there's no book on how to do that. There's no required training on how they do that. So it's really missed a lot. And also, without that education, lawyers are put in this really difficult position that makes that doesn't always work the best. And just an example of it getting missed. So one person described how she went to her lawyer, it was their first meeting, and she, in talking about why she was there, described how she had been raped by her husband. And then the lawyer told her, let's just get back to the legal stuff. So that kind of situation is happening, and accounts for those numbers as well. So all of this leads to people not asking for what actually they want for a safe arrangement. So, family law is not like negotiating a contract where everyone is just going to kind of put out a number and hopefully come back with something similar. You're really in these situations negotiating and trying to come to an agreement where people are safe. But that's sort of how it works. You can't actually ask for what you want. You can't actually say, this person has never been safe. They've recently threatened to kill me, and I have serious concerns about my child spending any time with them right now. Because if you ask that, you're going to look unreasonable, is what the perception is. You will be said to look unreasonable, and the fear is that you'll get even less than what you should have reasonably asked for. And when we talk about like what kind of system do we need, one of the biggest issues, again, is just this lack of baseline understanding about what family violence really is and what it looks like. Because what this leads to is everyone's trying to kind of figure out how this can go when they go forward, whether that's a negotiation, a mediation, a trial, a chambers application. You're trying to figure out how this can go. And that's what lawyers, are there for, if they can help you. But when you're dealing with a system that isn't set up with an understanding and what violence is, what it looks like, how it really impacts kids, and you're with judges who maybe know a lot about family violence, and maybe this is their first ever family file. You just don't know, and it's very difficult. And that whole unpredictable system is just a big part of the problem. Because you should be going through this situation that is extremely serious, extremely dangerous, and you should know that you're going to be met with someone who is a professional, who has experience in these issues, who is educated on what their decision is going to potentially do. And that's the big piece that's missing. And, Raji used the medical system example, which was so great, and just sort of another medical system example of like people are kind of going to their not a specialist in this area. If you have cancer, you need to go to an oncologist. You need to go to that person who has understanding. You don't go to the wrong doctor. And that's what people in family court, it's often people who've never practiced family law, which is fine. They can have education to bring them up to speed. And a lot of people who work in that are amazing and do great work, but it's such a high, it's a specialty. It's treated sort of like this thing that anyone can just go in there and figure out, and it's really dangerous. So an example of what this does is that women spoke of the vulnerable position they were in going through the court process. So in some cases, they felt that it made them even more vulnerable. So for example, one woman said she was really scared about having a family case conference because he was still really abusive. And so she asked, is there any way around it? And her lawyer said, well, technically yes, but in practice, it doesn't really work because it'll just make mom look unreasonable and bad. Unless there's a multiple assault convictions, it's really unlikely you're going to get out of this family case conference. So just thinking of that example, this is someone who has a lawyer. This is someone who is able to say, I'm really scared. And this is someone who is still currently experiencing violence. And this is sort of the position she's in. She's going to have to look bad if she doesn't want to go sit in a room with her abuser and a judge and try and have this forced 1 hour settlement that maybe she knows isn't going to work anyways. So not really user-centered. And one thing too, there's obviously the evidentiary burdens, which we all hear a lot about, particularly in criminal matters. So that's part of what ties into not being believed, is that's not necessarily always caught on video. So my ex is extremely crafty. He would never hit you. He'd never touch you, just so he could say, I've never laid a hand on her. But I just want to highlight that that is not necessarily all circumstances that are getting completely dismissed in family law. So one woman said, I had document after document after document showing evidence of the abuse, and it all came down to the court saying the kids need their dad in their life, but he hadn't been in their life for years. And when he was in their life, he abused all of us. And women talked about having medical records, police records, all of these secondary pieces of evidence that, again, isn't necessarily going to get you a beyond a reasonable doubt conviction in criminal court, but that's okay. That's not what she's trying to do. She's going through family law and trying to talk about what's safest for parenting. And it's just very difficult. And this is also one piece of, oftentimes it's sort of the court bending over backwards to ensure this parenting access or parenting time. And it's oftentimes just totally not what was even consistent with what was beforehand. then the process itself is impacts people's safety. So women describe sort of their safety being impacted before and after court, just that time and that physically having to be there. And the fact that in many areas, there's no safe place for you to sit. There's no safe place for you to wait. In circuit courts, you're often sitting there all day in a one-room courthouse waiting for your matter to be called. And just what kind of safety issues that raises. People were describing being followed after court, being intimidated before court. So a future process that can eliminate that need to be physically present, it would be huge. And actually, hopefully we're moving towards that thanks to COVID, with opening up technology and having phone-in court appearances. So court processes, people talked a lot about having to take the day off work to attend, and just the difficulty of maintaining employment while you're going through this court process. A lot of court processes, I just had this hearing that you don't know when you're going to be scheduled. You have a 2-week window, and I know that works in some rural areas, but the client then never can plan when to take a day off work, when to get childcare. It's just totally designed as if you're all just lawyers sitting and available to attend court within this 2-week window. So I also want to highlight, when we're talking about a system and why it needs to change, the health impacts of the current legal system are so significant. And when I went back to do that survey, I asked people about their health in a few questions, because I realized it came up a lot. People having chronic health health issues, particularly PTSD, following these court proceedings, and what that does to someone's entire life, even long after their family court matters are over. So in our survey, 80% of the women said that the court process had an impact on their health, and 62.5% said they developed a new health problem while their legal matter was proceeding. And many women described physical health problems that they attribute to the stress of court and the ongoing abuse. And a number of women whose mental health had declined rendered them permanently disabled and unable to continue working. A woman who had developed PTSD explained, "I had experienced trauma before, but the high stakes and forced proximity of the court process was too much for me." So in terms of having, I think the legal system has, and what we all decide on for our new court process that's coming up, hopefully, is sort of this rooting in how much this impacts people's entire life and ongoing health, and sort of centering it around, or we're doing a project right now where it's like, what would a court that's designed for people who have PTSD look like? What does that look like when you come into it? How do people treat you? How do the forms look? What kind of language are we using? What kind of lighting are we using? Just all these pieces, because it really does matter. I mean, the big piece is hopefully going to a place where there's family judges that want to hear your matters and have interest in keeping everyone safe, or I said that wrong, that have education in how to keep everybody safe. There we go. So just to highlight, there's these challenges that that I talked about and that Raj, you talked about. They're so significant in rural areas too, where the access to the resources is just that much more limited. So oftentimes people actually qualify for legal aid in some of these communities, but there's no legal aid lawyer who can help them, because there isn't any lawyers in that community who take legal aid, and it's just very difficult. And you're dealing with small RCMP detachments in a lot of those communities. And I mentioned the small courthouses themselves just being physically kind of a nightmare. So people talked a lot about just this feeling that they didn't know what was going on. Often they had lawyers too. So legalese is its own language. So an advocate said sometimes women would come back from appointments and the court, and they would say that lawyers are impatient with them. They didn't understand what the lawyers were saying, and the lawyers explained it twice and didn't want to explain it again. So the law involves its own language that is difficult for most people to understand and is inaccessible. I mean, it's so confusing what goes on in legal proceedings. My goodness. And I went just to the whole thing, law school, lawyer. It's just why? So when we think of what that does to someone who's really their safety, their child's safety, everything is really on the line, and they're going through a process probably by themselves, and they are going and they don't know what people are saying. And then so they help them by repeating what they're saying, but it's not actually in English. So it's in legalese. It's just really a fundamental piece. And then we think of this is English, and for people who speak English as an additional language, when you have legalese and you need that to be translated or interpreted, you need people, not anyone, but someone who can specifically interpret that court language. So if there was a more plain language, it would be easier to interpret and translate as well, making it overall more accessible. And right now, as I mentioned earlier, so it now is a great time, more than ever. Things really need to change because we know that violence, the severity and prevalence of violence has increased during the pandemic. And we know that there's great plans for us to all be at concerts in BC in September, and it's really exciting. The pandemic is hopefully in some parts of the world on its way downward. However, what we know from the ways in which violence has increased and the impact that has had on women experiencing violence, that type of incidence of the increase and the impact of that, we know from research such as in Hurricane Katrina, that those impacts are going to last well beyond sort of the end of the pandemic. So what I always think is, wouldn't it be great if we were so advanced that the lawyers and judges at this point or at the start of the pandemic were actually getting education on the ways in which the pandemic is increasing violence, things to look for during COVID-19 for the self-reps when it comes to a case where there's violence. And instead, we're still trying to get through that psychological violence is violence under the definition in the Family Law Act. So a big way to go. Our overall some recommendations, including total reform and new system, potentially for a unified court, is to have education be mandatory, to have more access to remote hearings and technology advancements, and to make meaningful referrals. So we need a legal system that is safe. And so currently the legal system is not designed to be violence informed or trauma informed. And, just the most blatant example of that is that there's currently no mandatory training for family law lawyers on family violence. There's no training in the BC Bar admission course on family violence. And most law students really don't receive any training on working with people who are experiencing interpersonal violence. So right now, it's sort of, it's not seen as this thing that's so integrated and a part of and that needs to be planned around. It's seen as this separate thing that practitioners can just sort of figure out on their own time, which totally disregards that family violence is extremely complex and frequently lethal, and it needs to have this whole design centered around it. When thinking about what we need, The most positive finding from our research was the impact that advocates and support workers have on people who are experiencing violence. I'm sure there's some on the call you were talked about across the province. So people talked about sort of this immense benefit that having a frontline advocate had to their life. A lot of people would say the name of the person who helped them and say, she saved my life. And that's someone who's part of it is that they're bringing this continuity to a file because, you know, legal aid hours run out, police move, you're getting a different judge every time. This is someone who is really an expert often in working with survivors of violence. They're often the people at transition houses or women's resource centers who are the experts and who really helped. So it's just interesting that that we have so much to learn as a legal system from people who aren't necessarily legally sort of always, they're not necessarily like the legal part, but they are the part that actually have the most impact where it really matters, and a system that's sort of designed to hear from them on how it should be designed, but also that incorporates them within every step is one of our recommendations. So with that, the other piece that we talk about, or I'll just sort of finish on, is this idea that the legal system is making things worse, is what our main finding was. In a lot of situations. So a lot of times people are coming there because they think, okay, this is what I have to do, is a lot of times why people are going there. But they're also thinking this will maybe assist me, this will maybe help me. And then they're left in a situation that is potentially more dangerous. So because we know that the advocates that people worked with were such a positive influence, and as well as other sort of community organizations can assisted people, one of our main recommendations is that lawyers and the legal system as a whole needs to sort of find ways to partner with these community organizations and with advocates and with people with that expertise, because even in this beautiful time in the future where every lawyer has a very expansive understanding of family violence and gets their annual training and is, all good, there's still not the person that can do that, that work with the client of really, making a safety plan, where assisting them with the day-to-day pieces of keeping them safe and working with them. It's just really a community resource that's more likely suited to that. So we asked if people would find that helpful, and 92% said yes. So we're trying to recommend sort of this meaningful referral of pairing people. Another piece is just that, as a lot of people know, a lot of people know to go to a lawyer often, but they don't necessarily think about what other resources can assist them, and they don't necessarily know what is available. So that's why lawyers are a good stop to know that information. I think I probably just mentioned all of this, so I will go on. Yeah, and sort of people come to the legal system, or they're lawyers, or they are in these situations, and as Zara Suleiman says, who is this person before me and what do they need that would assist them in having some of their basic issues addressed? And I think at least as lawyers, we're really told, to focus on the legal issue, and we're not social workers. That's not our expertise. That's not our job. But at the same time, if the system existed that was more wraparound, where someone coming to you can have at least some referral and help getting to that referral and appointment with their housing, because you can know that information. It's easy for you to have that information, those kind of pieces. And they're often the first professional that they reach out to is lawyers, which is why I always sort of reiterate that. And, you know, we know from the inquiries into domestic homicides over and over again, it's often that actually one person within the sphere of this person's life or this victim's life actually did know about the risks. And so anytime that there's an opportunity for collaboration between those actors, and I know some places do that so amazingly with you know, special units that are connected with the person, the police, and community resources and those types of things. So the more of that, the better. And some positive, there were positive experiences. I asked people if they had any positive experiences within every interview, and people described what was positive is when they were treated with empathy from lawyers and judges, when there were supports available, including advocates, and when they felt empowered. And, you know, Zara Jamali, who's a family law lawyer and mediator, said, "We are the gatekeepers of this legal information, and the more we can impart, the better we've left them." But that's sort of more geared towards lawyers. But just in general, this piece of empowering people when they can actually know what's going on. So when it is plain language that they don't need to have even full understanding of English for is what it should be designed for. And to understand and to know what their choices are, to know what kind of outcomes may happen, to know that the people they're appearing before are going to understand at least their experiences and what they're coming from in some way, or maybe even approaching it with humility. I think that is just such an important piece. And also this piece is just really highlights what one person can do, you know, while we wait for big changes. You know, people's individual interactions, as easy or as simple as they were, even a phone call has such an impact on people's lives, because every piece of it is often, you know, that part of they're not being believed, they're not being helped, they're being put in unsafe situations, and just one person not necessarily even having a substantive change, but just understanding that was huge. Because it's related, I just wanted to speak quickly, and I am excited to follow what NEVR does, and hopefully, you know, learn more about in tomorrow's session that I'm going to watch recorded later. But we're currently working from this research on creating safety in rural courthouses in BC. We're going to do a research project and hopefully, you know, connect with some people who are here in the future. And that's really coming from people describing these unsafe courthouse experiences and how that intersected with their safety concerns. So I just wanted to mention that, and hopefully connect to people in the future. I also just wanted to say, in case it is, if there's anything that is helpful within our 2021 publications, I've included them here. We're having a launch on June 22nd with Myrna McCallum about decolonizing family law through trauma-informed practices, and that report will be out then. This is just a link to the report I've been discussing. Next Thursday, we're having a discussion with Zara Suleiman, who's the primary author on the report that's linked here, that is more centered on what lawyers can do within the system, but is very related to today's discussion. And for anyone who works with people who have Section 211 reports, I wanted to link this report that we released this year as well. And I wanted to say thank you so much. Here's Rise's contact and my own. And thanks so much for your time.
Thank you, Haley. those were two very informative presentations, and we're going to go into a joint Q&A. And I've got a question that's addressed to both of you. Suki, do you want to come on screen and ask it, or do you want me to just read it? So the question is, do you support women who come to BC under a student visa or work permit visa and are dealing with criminal court and family court matters? Example, assaulted by their partner after 1 to 2 months of just arriving to BC and are now wanting a divorce, are in BC under a work permit, does not speak any English. Would I?
Oh, sorry. I can answer. RISE does provide some direct services, and the best way, I will put it in the chat, the best way to reach out to RISE is to do so through a brief online form that you fill out, and you actually then book an appointment with Andrea Bryson, who is our amazing case manager, and she helps connect women either with RISE or with whatever the best resource is. So she's just this great point person that I will put in the chat how to get in touch with her if anyone has any clients that need lawyers, need legal help, mostly for family law and some immigration. And then the other thing that she does that's great is if you ever have a client or you're helping someone who's been rejected from legal aid, she helps do the review process to try and get the person legal aid. So I'll write that in the chat.
Thank you, Hayley. If you wish to ask a question, you can either put up your hand, but it's better for me to see if you can use the hand emoji in reactions, because that then makes your screen come to my screen. Nobody's coming, so I'm going to take advantage of the fact that nobody is coming in right now. To ask Hayley if you would say a little bit more about the particular difficulties of the rural courts in BC.
Yeah, sure, thanks. I was going fast at the end, but there's more to say, and I'm sure lots of people work in rural areas, and it would be great to hear from you too about what your experiences are. So what we heard is that one issue is their court is very infrequent. So we know that in general, court takes forever. Everything takes so long. You think you're just going to go to court and it's like the movies, you have your trial next week. I mean, best circumstances, that's not happening. But in rural areas, because where you have circuit court, you're only sitting maybe once a month, maybe once every few weeks, maybe once every few months in some areas. And what you have is 2 days of court that you have, and then you have your family court matters typically go last. So that's a long way to say that court is infrequent, and you're often not going to have your matter heard when you're actually having court. So people end up having to sort of wait longer than they normally would in other areas. So delay is a big one. Getting to court is a huge issue, because in those areas where a court sits in a more central, for that region's place, people are traveling all over to get there. And now that we don't have Greyhound, a lot of places have no public transit. A lot of women hitchhike to go to court, or in some situations, the only way to get there was with like the bus that's used for when people need medical appointments, but then they needed to sort of have a medical reason, and just very difficult transiting there. And then just back to sort of that space issue. So it's often being held in a one-room court that because the family matters go at the end of the day, and I don't think people are necessarily told that. They're told come for 9, you have court at 9, and you sit around and sort of wait all day, and you're in this really small place, and with the person who was abusive towards you, maybe is still abusive towards you, and there's still safety concerns. And what people talked a lot about and is just the impact that, you know, if you have PTSD or sort of other types of trauma that you're experiencing, just the impact of having to be physically there and the impact of a look. People talked a lot about just that, like he would just like stare at me or he would give me that look, and I know that look, and it's just really re-traumatizing for people to not have a place to be separated. And lack of lawyers was a big one, and litigation abuse. This will be my last example. Sorry, I feel like I've taken a long time to answer this, but litigation abuse. One way that people, you know, continue to hurt their partner is they make it so they can't have a lawyer. And it's easy to do that. If you live in a place that only has 5 lawyers, you just phone them all and tell them a bit about your case, and you've conflicted out that person, all those lawyers, and now they can't represent that person. So that was an issue in a rural area, but I'd be happy to hear other people's experiences too.
Balbir, I see your hand.
Okay, unmuted finally. I guess mine's more of a comment in terms of what I've heard from both Raji and Haley, is that the re-victimization seems to be a pattern that occurs across our system, whether we're talking healthcare, social services, or courts. And to me, it's such an important matter, especially when I know it happens in healthcare, and being from healthcare, knowing that our standard are, for nurses anyways, and some other health professionals, is cultural safety. And yet our system doesn't practice cultural safety. There are, I'm sure, some really good individual health professionals who do. And so how do we get people to understand those impacts? Because you talked about health impacts, and I can tell you the research out there is vast in terms of violence and health impacts, you know, right from things like cancer that you don't think about, heart disease, diabetes, strokes, right? Chronic GI conditions, gastrointestinal system conditions. And so to me, they're interlinked. Like, I don't think there's a separation between the emotional impacts and the physical. And we can find lots of research on that too that integrates them, but our systems don't. Like, our systems are consistently in silos all the way across. Now, I know you've thought of the silo system. Do you have any ideas of how we can start integrating all the systems?
It's a really, yeah, it's a really, really important and big question. And I think sometimes, you know, it's a good reminder for us in the legal system to know about these shortcomings in healthcare, because often it looks like it's so much better because we're coming from a place that's so bad. And so, you know, I think, like, from the legal perspective, there's so many barriers, like even just going down to like how lawyers practice, and the like, you know, it's a self-governing profession that has a monopoly, and there's a lot of resistance to like changing the way the legal system is run and how what role lawyers play within it. I mean, to the point where, like, you know, it's a hue and cry to like think about expanding the scope of paralegals, for example, to be able to do some more substantive work. And so these are big challenges, and I think they really do kind of come from like having to like think beyond like tinkering at the margins of the systems, because the system is really sort of set up to kind of perpetuate itself, right? And the people within it at the moment are benefiting from it being set up that way, and aren't necessarily going to be motivated to like think about how they can be innovative. Like, I mean, RISE, I think, is a really good example where, at least in respect of bringing social work and other community supports into a legal setting and giving those frameworks as much validity and sort of centrality as the legal framework gets. I think there's like some possibility there. And know in Ontario, there's more medical legal partnerships that are happening where recognition of the health impact of legal matters and the legal impacts from healthcare issues are kind of being understood in a more coordinated way. That's something I think we could do a lot to learn from. And I think that there's other jurisdictions outside of Canada where there's been more movement and momentum on just kind of thinking about systems integration, kind of beyond even just like the different pieces of one kind of system. Like, you know, my presentation was just differences within only the legal system and how fractured that is. So let alone, you know, kind of being able to bring in like healthcare perspectives. I think from the perspective of lawyers, like cultural safety and kind of like impressing upon them how important it is to do this work, like has to really be tied to competence. You're just not competent to do this if you're not doing it in this way. And I think we kind of need to kind of get them where it hurts, kind of like it's a competency issue. You're not providing competent legal services if you are not screening for violence, if you are not, you know, being trained regularly and routinely and having updated training. Like these things, I think there are ways to kind of tie them together. And I know that some of the access to justice research that's happening now in Canada is getting like a little bit more nuanced around like what the actual cost is. And that includes like the costs to all of the systems, including our healthcare system. And so even if all you care about is the bottom line and you're only motivated by saving money, there's like kind of like a business case for making some of this integration happen. So I think those are just a couple of reflections. I certainly don't have the answer. And I know that there's, I think, a lot to be thinking about in terms of how, even as we think about an alternative model, how could we build some of these pieces into it so that it does feel like it's truly transforming these systems, as opposed to just kind of like tinkering a little bit on the margins and not necessarily getting into the substantive change we need.
Thank you. Haley, do you want to come in on that?
Follow up.
Okay, Balbir.
Well, I was gonna say, Raji, I totally agree with you. A lot of the challenges are in processes. It's not necessarily that we have to revamp the overall system in the sense of structures, but it's process. So how does one person relate with the other, right? Which gets right back to cultural safety. You know, are you treating them like human beings and, you know, with equal power? And when I listen to both of you and the language I know I've looked at for law, even, you know, with a doctoral degree, I find it difficult to understand some of the legalese that's used, right? Because law is not my area, it's specialized language, and I don't think it needs to be. I mean, it's set up from ancient days. It doesn't need to be like that. And so we have a lot of work cut out for us, and I'm glad we're all working together.
Thank you. I have another question. What requirements are required to have an expert's opinion accepted into court, either a medical expert or a trauma expert?
Haley, do you want to take that one because of all the work you've been doing with the 211s?
Sure. I'm actually just pulling up the report. I'm going to put the report in the chat too. But there's a legal test about whether or not that person, so basically what happens is you have to kind of apply to have that expert's evidence heard, and you kind of have this little mini trial. And it's called, anyways, doesn't matter what it's called. It's called obviously not a mini trial, which would make sense and is easy. It's called a voir dire, but anyways, so then at that, you have to sort of satisfy that this legal test, and the test is really whether or not it's necessary for the court. Like, do we need an expert to come and say what trauma is? Like, is that really something that, and when they look at that, they think, is that really something that someone doesn't know enough about, just reasonably kind of, so is it necessary? Is it relevant? Is it something that, is beyond the scope of what a judge should know? And then just another question of if it is kind of puts like potential bias if it's brought up. But I will send it. We have written this report about Section 211 reports, and they are this section of the Family Law Act, but it's just to say they're kind of an expert opinion, but they're kind of not, because they've been admitted to family court and they don't have to go through that process, and they have no scrutiny, and they're often very biased against women, is what we found in our research. Raji, do you have anything you want to add?
Just that it can, just that Haley's outlined the test. I think often outside of the family law context, I'm not a family law lawyer. I worked with the folks at RISE pretty closely, but I don't practice family law, and they do. And I've noticed this tendency to treat evidence differently in family law proceedings than in other kinds of civil cases, where there's like more kind of rigidity around how somebody will be qualified as an expert, what the scope of their expertise will be considered, and also like that kind of those barriers to entry around, like, is it something that the judge believes requires an expert opinion? And sometimes that can be a challenging barrier, because judges are not necessarily, there's some ego involved too in these systems, and individual people maybe have different ideas or inflated senses of what their knowledge is and where their like blind spots and gaps might be. And I think that can sometimes be a challenge as well, especially if it's a judge who's sort of like, well, I hear a lot of these kinds of cases, like I've got experience understanding what trauma is and how it shows up in these contexts. And you're like, well, do you really? Maybe like these 211 reports are a prime example. They often get just taken kind of as truth, but nobody's really challenging the methodology that was used to arrive at a particular opinion about somebody's wellness or fitness to parent. And it has like huge, profound consequences for moms in particular. And so I think it's a big question to like just be thinking about, like, how is the evidence introduced and how does it get incorporated and understood? Then it ultimately makes these findings that are then kind of like held to be the truth. And then sometimes if those are very, very damaging, it feels like it's like pushing a rock up a really steep hill to try to get that finding changed or dislodged or not kind of have that force. So I think it's a really important question to be just thinking through how is evidence brought into the systems, and if we're talking about integrating different systems, what are the evidentiary rules that apply in these different systems, and how will they interact with one another?
Oh, sorry.
Go on, Haley.
Okay, can I just add, because this is being recorded and it'll haunt me. I said, so if whether or not it's necessary, relevant, and then the person has to actually be qualified. And then there's this piece about maybe there's another rule that says they can't testify. So, but I'm guessing maybe your question comes too from like wondering if we can, why those types of people aren't called in court more often, and that sort of comes up a lot of why, like, people are often not believed when they describe their experiences of domestic violence, particularly when there isn't sort of this hard evidence, even though someone's testimony is evidence. that people often sort of wonder about that. And it would be a really great, if that was sort of more the norm, where people came and described those experiences from an expert lens to help the court understand. That's sort of the purpose of experts, is they're there to provide this expertise that maybe the court doesn't have. And that's really what is missing. So yes, thank you.
Further to that, we've got another comment. Aren't Section 211 reports done by family justice counsellors who have an undergrad degree and a few other courses in mediation? I don't know if you would like to address that. And then another question is, any further thoughts on using more nurse experts in courts? We have an amazing plethora of expert nurses in BC who specialise in violence. It seems that we are told you're not a doctor and dismissed as non-medical experts. So thoughts on either of those, please.
I can answer the 211 one. Yes, that's right, Joanne. A lot of the 211 reports are done by family justice counselors. They're a bit different in what they contain, but I don't actually know what they have a degree in, but just to say that our research, when we talked about Section 211 reports, are really by the ones that are being done by psychologists who are also implementing sort of psychological tests, and it ends up being, in a lot of cases, like a $100 report, on average costs $16,000, and very difficult to challenge it. So those were what we focused on. The family justice counselor reports are a bit different, but you're right, they're definitely being done by and large by family justice counselors.
Right, and so they don't. I have some experience. I used to do the what do you call them? When someone's going through the court process, they have to do this seminar, 3-hour seminar. So I used to do that. So the family justice counselors would come to that, and they could have a degree in anything really, and then they'd have about a number of courses in mediation and family conflict and so on through the Justice Institute on top of that. But they weren't necessarily counselors or social workers or anything like that to begin with. The other thing that I just put in the chat was that I had a lawyer tell me they wanted me to come in and testify for a client. I used to have a private practice. And I said, I'm not an expert because I'm a counselor. And the lawyer told me I was an expert because I knew more in my field than the general public would know. So I thought that was a weird qualification to be an expert, but anyway.
Oh, go ahead, Haley.
I think family justice counselors actually have they have more requirement for family violence education than I know of, than psychologists, and they have a prescribed form for screening for family violence. So just in general, our view is that they're set up in a better position to do a better job with family violence than the psychologists who don't have those things.
And would either of you like to comment on nurse experts in courts?
Yeah, I'm not at all surprised to hear Hannah's experience about being dismissed or having nurses being dismissed, because the legal system, in my experience, is just kind of like a microcosm of the kind of biases and like credentialing and professionalization that we see in society at large. And so, you know, even in the number of cases that I've been involved in where there have been experts, you're looking at kind of people with these advanced degrees, and it matters, you know, whether they got the degree from like this university or that university. And there's just a lot of like kind of power and privilege and kind of hierarchy built into these processes. I think, as Bill Beer said, like these systems they're not neutral. You know, they were created kind of with a dominant kind of mainstream mindset, and I think that like it is an uphill battle to have the expertise of people recognized, like nurses with this specialization in violence. I think it's possible and it can be done, but I think the default still is, unfortunately, this idea of, you know, an expert has to have certain types of qualifications, and those map into like the hierarchies that exist in all of the different professions that we have. And so I see like a psychiatrist or someone with a PhD who maybe doesn't necessarily have the same experience working with clients on a direct level, may be regarded as a better, kind of a more credible expert, only because of those educational attainments and achievements that are, that I think are quite just kind of replicating some of those pieces in society. So it's not a surprise to me. I think it's really crappy because sometimes the court doesn't get the best information. And I think that lawyers have to be better at like persuading those judges about what the expertise is that's needed and who's best able to provide that evidence.
Thank you. Raji, in your presentation, you mentioned the psychiatrist, psychologist reports and how that's going to be a danger to a woman when those reports are then used in some other aspect of her life. Could you give a bit more information upon that?
Yeah, I actually commend the report that Rise put together that Haley has linked to in the chat. One of the experiences that like many women have told to us at West Coast Leaf when they reach out for support is around like, having the other parties like sort of requesting a psychological assessment, a Section 211 report. And often it comes in, it's maybe not, the woman may not have had a lawyer, or her lawyer may not have sort of challenged some of the ways in which findings were made in that report about her mental health or about her parenting capacity and things like that. And then because that's sort of accepted unquestioningly by the judge in a proceeding, it sort of becomes like a truth that haunts that person sort of as they are moving through the system. And if they have opportunities to, maybe try to have an order varied in some way, there's like a change in circumstances or something, there's still kind of that report, maybe if it's not well done, and many of them I think do tend to be pathologizing, it kind of then is there hanging over her as something that she has to kind of surmount, when in fact it's questionable whether that evidence was necessarily kind of really brought in the best possible way to begin with. But now it's there, and it's like often the resources aren't there to properly challenge it or to provide a rebuttal report, because these reports can be very expensive. The family justice counselors there's often a big long waiting list to get them. Sometimes the report is a requirement by the court to like sort of move things forward, and it can just kind of result in this constellation of experiences that can kind of then they sort of then kind of freeze you in time to that point in time and what was found about you at that time, and then it kind of just keeps sort of a bit like on repeat. And we've had women who have called like just in a panic because they've got this really terrible report and they don't know how they're going to possibly challenge it. And they know that it's going to have huge implications for their continued engagement in the legal system, because someone will be like, oh, a judge believed this or took this to be the truth of your capacity. So therefore you now have to, kind of get over that hurdle before anybody will look at the situation with a fresh vision.
Thank you. I'm not seeing any further questions at the moment. Is there anything further either you would like to comment on? And I'd also like to ask you, if you've got a hot link in your presentation, of course it won't work in this forum. So if you wouldn't mind putting that link, if you were linking to anything in your presentation, sticking them in the chat. Haley?
Okay, I linked to a lot of things because I thought my slides would be sent. Is that possible? Is everyone on an email list? Or I can link, I can do that, no problem, but sure. I'll just add about section 211 reports that they also, when we think of the, like what Raji said, is they kind of become this truth and then it follows people and they're very hard to challenge and they're very expensive. So this truth is built by what the psychologist writes. And what we heard in our research over and over again is that they don't actually put in a lot of times what the women describe about their experiences of violence. It's just not included or it's dismissed. And this is often, you know, the time that the evidence is coming up. So this report either says it didn't happen or doesn't include it at all. And then that now is being brought forward. So family violence is just evaporated from what actually happens. And also what evaporates or what isn't included in any meaningful way from a lot of the reports I reviewed is any reflection of, you know, what people's background and cultural experiences, how that influences their lives and their families. And it's really looked at from this, you know, white perspective of what the definition of family is. And the tests that have been made that exist, I don't know, they're not made for someone, they don't assess parenting, they aren't made for someone who's experiencing trauma. They've been completely, you know, called out for being culturally inappropriate and shouldn't be used. So those are two other big pieces. Violence is missing and there's no cultural humility or respect often within the reports.
Thanks, Haley. If you want to just put your PowerPoint slides in the chat, that would probably get it distributed to everybody. Albir.
Oh, I have her slides. I was going to say I can put them up on the NEVR website, but I can definitely just throw them in the chat too.
So this is a question for Balbir. We have people who are not able to attend tomorrow and asking about where would be able to watch Friday's session. Eventually the NEVR website, but do you have a time frame?
Oh God, give me till middle of next week to get them all up.
Thank you. So just looking there, I'm looking to make sure before I ask the question that there's nobody else is wanting to ask a question. Haley, I'm interested in your methodology because, you know, I'm a social scientist. How did you find your participants? Were they snowball sampling, former clients?
Former clients, we partnered with community, like a place in each community. So like a transition house or a women's resource center. And we partnered with them as our host because we tried to design it as being trauma informed. And we really wanted to have a place that people were familiar with and have a support person available at every session. And so, for example, if we're in a certain place at a transition house, we then sort of are working with advocates and they're helping to recruit people. They often had already, they said, oh, I know who I should ask. And we put up flyers and that sort of thing as well.
Okay, thank you. Okay, people, I'm putting out a call for questions, or otherwise we're going to move on with the program. I think you've provided us with so much information and rich detail that nobody's left with any gaps. Thank you both so much. So I'm making the executive decision that we are going to move up into the networking opportunity, which is when we are all going to get randomly assigned to different breakout rooms for 10 minutes or so to just talk to each other and to just find out a little bit about each other. If we were at a real conference, you would be doing this over a cup of coffee. So when you get to a room, and you maybe be about 8 people in it, then please introduce yourself, what agency you're from, or you might meet up with someone that you've already been in a partnership with, like Haley was discussing. Before we go into those rooms, I still have prizes. So we're going to take 5 minutes or so to answer. The first 5 correct answers to this question will receive $25 President's Choice gift cards donated by Pix. Thank you, Pix. Now, Balbir gave the answer in her presentation this morning, so no excuses, everyone. Thank you, Raji. What year was NEVR founded? First 5 correct answers get the prize. Nothing yet. Keep trying, people. They've not got to 5 yet.
I'll give you a hint. There are a couple who have it right.
There's 2 so far, yes. Three people have got it right so far. You can have a second guess, folks. Don't feel that you've only got a 1 chance here.
All the students working with us should know. I don't see them guessing.
Kirsten's got it correct, but I don't know of a last name, Kirsten. And Sonny, you're the last person. Congratulations. So the first person to get it right was our very own Joanne Drummond. Thank you, Joanne. Then Haley, then Natalie Bennett, Kirsten without a surname, and Sonny Verk. Congratulations. I'll be in touch with your prizes. Thank you for the name. Okay, so we are going to be, AJ is going to take us in. What I'm going to suggest is that we do 10 minutes in this breakout room, then we all come back here, and then we'll do another 10 minutes in another breakout room. Obviously, if you don't want to do this, you just disappear. Just don't come in. All right, so AJ, over to you to magically move us all.
So I'm going to open the rooms now.
Thank you. So that was a little practice for tomorrow when we go into our breakout rooms to actually discuss the questions that are published in your program. So if you wouldn't mind having a little think about those questions, they're listed on day 3, which is the pros and cons of different court models, and in an ideal world, what would be our wish list? Give that some thought. We are very, very interested in hearing from as wide a range of people as possible. And so tomorrow when we go into the breakout rooms, there actually will be a moderator from NEVR, whose job it is to just make sure everybody gets a chance to speak and to report back briefly when we come back to a full session. So when you go into groups tomorrow, we may, AJ may have to move the moderators around because, as luck will have it, all the moderators will end up in the same group. So, does anybody want to speak in the big group, or are we prepared to go back into another breakout networking? Okay, AJ, work your magic, please. Well, thank you everyone for sharing. Sorry, Natalie, you disappeared off of ours. I don't know if you want to introduce yourself to the whole group.
My name is Natalie Bennett. I'm a probation officer at Surrey East Community Corrections. Been doing this for about 14 years and I'm pursuing my master's of counseling right now.
And after she got that out, she disappeared.
Yeah, I went to another room.
So we have 5 more minutes of today, and I'm going to offer those 5 minutes to Balbir as one of our co-founders to say, is there anything you want to say and wrap up, Balbir?
I think we had 2 more very informative presentations that's going to help us tomorrow, and we're going to get 2 more tomorrow. So that's a lot of information for us to process. So I hope you're going to do some resting of some sort tonight, so you re-energize. And a lot of this work is really, really hard. And some of the things we are hearing are not necessarily new. You're on the front lines. You've heard a lot of these before. I mean, I have certainly heard these before from many of you, as well as read in the literature about all these things. So to me, this is an opportunity for us just to put our minds together and say, these issues have persisted for a very long time. We need to take action, and we're going to take it now. We're going to produce a comprehensive report that's going to be backed up by literature. I don't know how extensive, depends what timelines we want to set for ourselves, but I anticipate getting the report out to you guys as soon as we can get it together so that you can go through it, make sure we've included all your ideas and some of the pitfalls too. If we pick certain models, like if the report says we picked, I don't know, ABC, and you can just see that that's going to lead to some kind of harm for the survivors, you need to speak up and tell us, right? To me, everybody has equal voice. There might be a few writers, or if you want to write the report with us, you're more than welcome to. Like anything we do with NEVR is never closed. It's always an open process. And even the book that we published last year, if people want to read and contribute, or they think, oh, you're out of date, we need this in there, we're more than happy to have you co-author anything we've written. So I think just keep that in mind. And never is all of you. It's us trying to represent the people who don't put their voices forward. Or when we started, I was told that the reason they wanted me to start it and lead it is because they were fearful. The service providers were fearful that their funding would be cut if they spoke up against government, against governing bodies, etc. So, and I have no fear of that. I work in post-secondary, and I think it would take a lot for somebody to fire me out of a position I've held for over 30 years. So I am ready to raise hell with all your backing. Yeah, I've wanted to do it for years, since our first report on courts was in 2011. We started with courts as our challenge, but my thinking back then was with our whole group saying, you know what, we don't want to upset the apple cart too much because we still have to work with government. So let's give them the report and ask them to make all these changes. Small changes have been made along the way, and they've kept us informed, but not what is required. And I guess we'll be asking this government, do they have the courage to do bold change? Because that's what it comes to. And I've been told before that if you don't have judges on board, you can't change a court system. They're independent. So we're going to have to work hard all of us work hard to find judge allies. And I'm hoping Catherine will be one of our allies She stayed for the whole conference yesterday and she was here earlier, but probably had work to do. But yeah, so that's sort of the thing. And I just really want to thank all of you for wanting to work on this issue and being here today. And I know everyone is so busy. So just taking that time is really appreciated. And thank you. And Jen, thank you for emceeing and keeping us on track. I know that's not easy. And now we have technology to deal with on top of that. So thank you.
Well, thank you, Balbir. On that note, it is now 4 p.m. and so you're free, but I'm asking Corin and Ty and Balbir to stay around for about another 5 minutes.
Okay.
We just